Hi, Assalamualaikum and welcome to our video. In this video, we are going to discuss an important case, which is the case of Tenaga Nasional Malaysia and Batu Kemas Industri Sdn Bhd. Let's go! To begin, let's look to the details of the case. So the full citation of this case is Tenaga Nasional Malaysia and Batu Kemas Industri Sdn Bhd and another appeal 2018 5 Malaysian Law Journal 561. This is an appeal case that was heard in the Federal Court of Putrajaya, and there are some panel of judges involved in deciding this case, which is the first one is Hassanlah Federal Court Judge, Azhar Muhammad Federal Court Judge, Zahra Ibrahim Federal Court Judge, Baila Yusof Federal Court Judge, and last one is Fatin Federal Court Judge, and the decision was delivered on 26th of April in 2018.
Next, there are three main parties involved in this case. First, the plaintiff, Batu Kemas Industri Sdn Bhd, which is a manufacturing company that operated a factory that was heavily relied on highly sensitive and operated machinery. Any electricity supply disruption could lead to a serious consequence to their production process. Second, the first defendant, Government of Malaysia, who acted through the Public Works Department, or mostly known as PWD. In this case, the PWD was responsible for overseeing the highway construction work near the plaintiff's factory. And the third one, the second defendant, Tenaga Nasional Bhd, or also known as TNB, which is Malaysia's national electricity supplier. In this case, TNB was responsible in order to supply and also maintaining the electricity infrastructure to the plaintiff's factory. And there was also a contractor known as Markas Perdana Sdn Bhd, who was appointed by PWD, which played a critical role in this case as their construction work ultimately led to the incident in this case.
So what actually happens in this case? Basically, it started when the plaintiff sued the first and second defendant for causing electricity supply disruption and caused damage to the plaintiff's expensive machinery and also affected their production. The first defendant, who is a Government of Malaysia, appointed a contractor known as Markas to conduct works on a highway. During the works, they accidentally ruptured an underground cables while installing the guardrails. But before the works began, they already written 3 letters to the second defendant requesting the cables to be removed or relocated. However, the second defendant ignored the letters. Instead, they removed the overhead cables and left the underground cables untouched. During the trials, the court dismissed the plaintiff's claim on the ground that the plaintiff had contributed to the negligence. But the Court of Appeal reversed the High Court decision and held that the first and second defendants was liable for negligence and there's no contributory negligence on part of the plaintiff. Subsequently, both defendants obtained leave question to appeal to the Federal Court.
After analysing the fact of the case, the Federal Court had addressed two major legal issues in this case. The first issue, whether the pure economic loss, means financial loss that was not directly linked to the physical injury, could be recoverable in the claims of negligence involving the electricity disruption. And the second issue, concerning on the contributory negligence, specifically whether the plaintiff's failure to apply the surge protection system could absolve completely the liability of the defendants. These issues are crucial because they define the boundaries of negligence claims against the public utility provider and also clarify the legal responsibilities of commercial consumers.
So now we are moving to the plaintiff's argument. In this case, there are 3 main arguments that brought by the plaintiff. The first one is regarding the first and second leave question, where the plaintiff submitted that the defendant's argument was based on the several factual grounds. The first one is the second defendant had admitted their negligence by paying the compound. Secondly, the plaintiff submitted that PWD was aware that the construction will interfere with the underground cables, yet they still allowed the works to proceed despite this awareness. Thirdly, the second defendant also had a duty to place cable markers, but they failed to do so. And last but not least, the second defendant failed to provide any information regarding the location of the underground cable, and this failure amounted to the irresponsible omission. So the second argument brought by the plaintiff is that regarding to the third leave question, which plaintiff submitted that this question was misconceived as it was based on 2 incorrect assumptions, which is the first one is the assumption that second defendants being a public bodies, but the plaintiff argued that the second defendant is a private entity which incorporated under Companies Act 1965 and merely hold a license under Section 9 of the same Act. So the second incorrect assumption was that the plaintiff's claim was for pure economic loss, but the plaintiff submitted that the disruption of power supply caused by the damaged cable had resulted in damage to their machinery. And this submission supported by defendants' own internal reports. Therefore, the plaintiff submitted that the claim was on the physical injury, not the pure economic loss. So for the third argument is argument regarding to the fourth leave question, which the plaintiff submitted that there is no statutory provision that exempted the second defendant from the liability. So in the absence of any statutory exemption, protecting the second defendant liability would still remain. Therefore, the plaintiff argued that the second defendant owed a duty of towards the plaintiff.
The defendants denied liability and also raised several defences. The MB argued that the damage was caused by undervoltage, not the power surge, and the plaintiff is the one who failed to install adequate power system protection. They claim that this failure is amount to contributory negligence and should be operated as full, complete defence. In addition, the MB argued that poor economic loss was not recoverable under the malicious negligence law, particularly in case involving power electricity supply. Other than that, they raised concern on public policy, warning that allowing such claim could open the floodgate to litigation and also lead to increase of electricity tariff. And the government of Malaysia, as the first defendant, argued that they had taken reasonable step by notifying the TMB and also should not be responsible for the contractor's actions.
So now we are discussing on the legal principle applied in this case. The first principle is the duty of care. Referring to the case of Donahue and Stevenson, the plaintiff drank a bottle of ginger beer which contained a decomposed snail, and the plaintiff became ill and sued the manufacturer even though she had no contract with the manufacturer. And the court held that a manufacturer owes a duty of care to the consumer who are likely to be affected by their products. And this case also established the general concept of duty of care in negligence, which is the first one is the forcibility, which means that the damage suffered must be something that could be reasonably foreseeable and predicted as a result of the defendant's act or omission. And it can be proven in the case of Stewart and West African Terminus, where the court held that liability only arises where the injury is reasonably foreseeable. The second general concept established from the case of Donahue and Stevenson is the proximity. Proximity refers to the sufficiently close and direct relationship between the plaintiff and also the defendant. And according to case of Clerk and Linsell, proximity may exist in three forms, which is physical, circumstantial, and also causal proximity. So in the latter case, which is the case of Caparo, it established a new test to determine the duty of care, which is known as the Caparo test. So in this case, the court established three elements that need to be satisfied in order to impose a duty of care, which is the first one is possibility of damage, the second one is proximity between the parties, and the third element is it must be fair, just, and reasonable to impose the liability. So for the third element, it requires the court to balance public policy consideration. As in the case of Barrett and Enfield, London Borough Council, the issue was whether the local authority owed a duty of care in the way it exercised its statutory powers, and the court held that the policy consideration must be examined before imposing the liability, especially when it involves a public authority. So for the second principle applied in this case is the pure economic loss. So in the case of Fatin Steels and Alloy Limited and Martin, the plaintiff operated a factory producing metal alloys, and the defendant negligently damaged underground electricity cable while carrying out excavation works. As a result, electricity supply was cut for several hours and the machinery was damaged, molten metal in production was destroyed, and the factory could not operate, causing loss of profit. So in this case, the plaintiff claimed three types of loss, which is damage to the metal, loss of profit from the damaged metals, and also loss of profit due to the shutdown of the factory. And the court held that the pure economic loss, unconnected to the physical damage is generally not recoverable in negligence. So for the third principles applied in this case is the contributory negligence. So in the case of R and Sultan Canada Power, the court defined contributory negligence as a failure of a person to exercise reasonable care for their own safety or property. And contributory negligence exists where the plaintiff negligence has materially contributed to the harm suffered, and if it was proven, the court may reduce the damage given to the plaintiff according to the plaintiff's share of responsibility.
The ratio descendant of this case lies on the court's reasoning on causation and liability. The Federal Court held that the rupture underground cable was the direct cause for the injury to the plaintiff. The MB was negligent for failing to move or relocated the underground cable despite was requested many times by other parties. The government was held liable and responsible for its contractor's action. And for the plaintiff, although they failed to install the surge arrestor and was therefore contribute to the negligence, it is believed that their omission by itself did not cause the damage. And the court emphasised that contributory negligence merely reduced the defender's liability, not completely eliminate it. However, by reinforcing the long-standing principle of negligence law, the element of or the claim of pure economic loss was not recoverable.
So here we come to the judgment of the case, and in this case, the court held that the plaintiff can claim for damage of economic loss that caused by the physical injury and not for the pure economic loss. As example, the first one is damaged machinery, the second one is loss of production caused by the damaged machinery, and the third one is loss of profit caused by the physical injury. And the court also found that the there's contributing negligence on part of the plaintiffs. However, it is not substantial and much lesser than the defendant's negligence. And the defendant should bear major part of the negligence, namely 2/3 of the liability. And the court given that the first defendant liable for 40% of the liability, and the second defendant is 60% of the liability. So the court awarded damages to the plaintiff on the loss of good in production and the profits, and loss of production and the profit. And the court also awarded damages for replacement and repair cost of the damaged machine. And also, the defendant need to pay 2/3 of the damages assessed to the plaintiff.
Last but not least, for the case evaluation, we believe that this case is important because it strikes a balance between protecting the consumer and also excessive liability for public utilities. Other than that, it also reinforced the traditional rule, which is pure economic loss cannot be recoverable in negligence, especially in the case involving electricity supply. At the same time, the court also firmly rejects the notion that contributory negligence should be applied as complete defense.
The decision also provides a clarity on the duties of electricity suppliers and set an important precedent for future commercial negligence claims in Malaysia. This case also remains a leading authority on the negligence, electricity supply and also economic loss.
That's all from us. Thank you.